So hi everyone, as Hayley said, my name is Nicole Lee. I'm one of the senior solicitors at SEN Legal, and I am going to be speaking to you today about the legal framework around ceasing to maintain an EHC plan, or more accurately, how to avoid an EHC plan being ceased. I have received lots of questions in the background, so thank you for sending those in advance. The majority of them, hopefully, are going to be answered as part of the PowerPoint presentation itself. But as Hayley said, we do have everybody in the background answering more specific questions as we go along. So fingers crossed we'll be able to cover everything that we've been asked beforehand. So a bit of housekeeping. This advice is all accurate in terms of the law being accurate, and hopefully you'll all be able to see how to apply it to your own situation. But just so, to cover ourselves, please do take specific advice about your specific circumstances if you're unsure. This is all very general, intended to be general advice rather than specific advice particular to your case. So I wanted to start off the talk with a bit of myth busting, because obviously in the line of work that we do, we see a lot of trends, we see a lot of the same wording, and we see a lot of the things that local authorities get up to. So I just wanted to impart some of that on you. I assume that most of you know this already, but for the avoidance of doubt, just in case you don't, an EHC plan can continue up until the end of the academic year in which a young person turns 25. So for all of the questions that were coming in saying, my child is 16, my child is 18, 19, 20, does that mean the local authority get to cease to maintain the plan? The short answer to that is no. Under the Children and Families Act, the EHC plan can continue up until the end of the academic year in which that young person turns 25. So you have an October birthday, that plan can continue until the July after that young person has turned 25. In practice, what do we see? And again, we've had a lot of questions come in, and the age of 16 has been mentioned, which isn't one we come across a lot. In practice, the most dangerous, if you like, transition period that we see tends to be when young people are moving from one post-16 place to another. So you're either moving on from one college to another, potentially a mainstream college, and now you're looking at more specialist residential provision, or if a young person has been at one college for an extended period of time. Local authorities tend to like to set timescales on courses, so they may say this course is a 2-year course, it's a 3-year course. That is all a local authority created construct, and sometimes colleges like to run in that way as well. But actually, for the purposes of the Children and Families Act and for EHC plans, there isn't any time period. It can continue for as long as it needs to. But we tend to see as a trend this time, at the ages of 18, 19, when we're moving between placements or when we've been in a placement for a while, that's when we see the cease to maintain decisions come through. It is very unusual to see a cease to maintain decision before that age group, but it's not impossible. For those of you that tuned into Hayley's webinar last week or who have caught up on our social media since then, you'll have seen that she discussed that cease to maintain is actually a decision that can come through after any annual review. So it could in theory be done at any time if the local authority deem that the EHC plan is no longer necessary. So why is the age of 18 to 9 so dangerous in terms of ceasing to maintain plans? Now, I don't work for a local authority and I never have, so I can't profess to know the inner workings of their mind. However, it tends to correlate to a moving over from children's services to adult services. And what we see time and again in these decision letters is we've decided to cease your child's EHC plan because we've reviewed the provision and we've reviewed the needs, and we have decided that those needs are now either health or social care needs. Now that bears no correlation to the law, as you're probably not that surprised to hear. So I've set out there section 21.5 of the Children and Families Act, which creates the correct statutory definition of what special educational provision is. And what it says is that any healthcare or social care provision which has the effect of educating or training a child or young person is to be treated as special educational provision and not health or social care provision. What local authorities tend to do is say your child is now 18 and magically overnight those needs have transitioned. They are now social care needs or healthcare needs, and therefore an EHC plan is no longer required. That's completely inaccurate. The correct definition is there, And I would suggest that it has a lot to do with the fact that now the education team or the education department are wanting to foist that provision off onto onto adult services and onto adult social care. So there is a procedure to be followed. Hopefully there are lots of local authority people out there today listening, because I'm not sure that they're fully aware of it, but I'm going to talk you through it, because if that procedure isn't followed, then there are things that you can do about it. So the Code of Practice at para 9205 sets out that where a local authority is actually considering ceasing to maintain, note the word considering, then they must first inform the child's parent or the young person that they are considering this. It should never be a surprise to you to receive a cease to maintain letter. You should first have been advised that the local authority is considering it. If you've received a decision letter that says that they are ceasing to maintain the EHC plan and you had no idea that it was coming, then they have not followed the correct procedure. Once they've informed you that they're considering ceasing to maintain the plan, they must consult both you and your young person if they have the capacity and the ability to be consulted about that. They must also consult the school or other institution, college, insert appropriate placement here, that is named in the EHC plan. They have to go through those consultations. If they haven't gone through the consultations, then they haven't followed the law, and the decision that they've issued to you is in its very foundation unlawful. Okay, overwhelmingly, and I mean overwhelmingly, in fact, disappointingly, I don't think I've seen one in as many years, I haven't seen a decision that followed the correct procedure. And unfortunately, a lot of parents do come to us with cease to maintain decisions that they weren't expecting. It's come completely out of the blue in some cases, and often it hasn't even been linked to an annual review. Or an annual review was a long time ago, and they're purporting that it was linked to the review. So that is the procedure in brief that they should be following before you actually get to the point of receiving the cease to maintain letter. In addition to requiring them to consult with you, there are other things as well the local authority should be doing that it's well worth noting. So if your young person is 18 or over and has transitioned over to adult services and is in receipt of adult services, then they should be involved in the consultation. So the education department should be contacting adult services and advising them, we are considering ceasing to maintain this EHC plan, and involving them in the consultation. They also have to be advising them of the decision, and there's a very practical reason for that. And that is, if an EHC plan is to cease, the expectation is that the care plan and adult services will essentially take over all of the provision for that young person. It may also require, and in most cases will require, a reassessment of care needs by adult services to make sure that social care don't have to step in to fill all of that time that was previously filled by college. The Code of Practice also suggests that support should generally cease at the end of the academic year to allow children and young people time to actually finish that programme of study. Now, that is a very sensible thing for the Code of Practice to say, and I would wholeheartedly agree with it. The problem that you see in practice is that local authorities generally aren't overly organised. The end of the school year, although it's in July every year, seems to take them by surprise. And then you will receive a cease to maintain notification, which isn't in accordance with all of the legal procedures that they're supposed to follow. It will be out of the blue, and it will probably say something like, the plan will cease automatically at the end of the year. I have had a cease to maintain decision come through that said the plan will cease in 7 days. That's completely unlawful. I will get onto that. But that is what you might expect to see. Also, at paragraph 9.206, if the local authority do decide to cease to maintain the plan, they have to notify the local care commissioning group of that decision. That is on the basis that any therapeutic provision that would have otherwise been deemed as health, so your speech and language therapy, your occupational therapy, all of which quite correctly are special educational needs and provision and should have been in the educational sections of the EHC plan, may need to continue after that plan has ceased, and it would be the CCG's responsibility to pick that up. Now, if they don't follow that procedure, I said there is something that you can do about it, and there's two options. You can appeal to the SEND Tribunal, which I'll sort of go on to a little bit later, but you will have your right of appeal, assuming that they've issued a legally correct letter. However, if the correct legal procedure hasn't been followed, then you may have the basis for issuing what's called a pre-action protocol letter. Now, a pre-action protocol letter, for those of you that haven't come across this before, it's a legal letter. It's got a very strict legal format. It goes off to the local authority's legal department and the head of children's and or adult services as appropriate. And it sets out that the local authority have behaved unlawfully because, and then you would list all the ways in which they've behaved unlawfully. In this circumstance, they haven't complied with the requirements of the Code of Practice. They've unlawfully issued the decision to cease to maintain. So what you would be asking them is to actually withdraw that decision and to start the consultation appropriately. Now, a lot of people will be thinking, well, why would we do that? Because we have our right of appeal to the SEND Tribunal, we have a right of redress, and actually the percentages in the SEND Tribunal, just to partially answer a question that came in just before the start of this webinar, is very good. The percentages for successful parental and young people appeals are very much in favour of the parent and young person. So why would we issue a pre-action letter? The reason that we might do that is that this will automatically buy your child more time in education, regardless of the fact the local authority are intending to cease to maintain the EHC plan. And that is because Section 45, subsection 4 of the Children and Families Act does not allow the local authority to cease to maintain the EHC plan whilst you have a valid right of appeal. Okay, so once you get the decision letter through, they've ceased to maintain, and they may say we're doing it in 7 days and 15 days at the end of term, it doesn't matter. They legally cannot cease to maintain that EHC plan while you have the right of appeal. If you get them to withdraw that decision and start the consultation, even that timescale isn't ticking. Now, quite often consultations can take a while. In the context of the wider COVID pandemic, we're seeing things taking longer and longer, deadlines being missed, departments are quite overwhelmed. And schools themselves, of course, have got quite a lot to be getting on with at the moment and probably don't have the time that they would like to respond to consultations in a timely fashion. So if you get them to withdraw that decision through a pre-action letter, that plan will continue. Now, the local authority may well only pay lip service to the consultation, and it may not matter what you or the school say, but every week that you delay the issuing of that letter, you extend the life of that EHC plan by a week. Sometimes consultations could take anything up to 6 to 12 weeks. So you could look at actually buying your child an extra half term up to a term in education purely by issuing a letter that's going to cost you a couple of £100. Now, for some people, it might not be worth it. It's very much on a case specific basis. But if your child is in a very expensive independent placement, some of these placements costing anywhere between 30 and 75,000 a term, then that cost benefit may well weigh in favour of trying to get that decision reversed in the first instance for the consultation to take place. Okay, if you decide not to go down that route, that's absolutely fine. You do have your right of appeal to the SEND Tribunal. Now, that right of appeal will run for 2 months from the date of the covering letter. So if the date of the covering letter was the 13th of January, then it would automatically run to the 13th of March. As many of you will know, before you can actually appeal to the SEND Tribunal, you first have to obtain your mediation certificate. You can obtain that mediation certificate at any time up to, in this scenario, the 13th of March. So any time before that 2-month window, you can contact the mediator and request a mediation certificate. Once you receive that certificate, your right of appeal will be extended by 30 days. 30 days from the date of the certificate, your appeal would have to go in. That's another 3 months. In that period, the local authority cannot cease to maintain that EHC plan. They have to maintain it. They have to be acting on the basis that your child is going to need a placement from the following September. If you're in a phased transfer situation, they can't cease to maintain. They have to keep on progressing that EHC plan as if it was fully in force, as if they had no intention then of ceasing to maintain it. Moving on from that, Section 45, subsection 4B, sets out that where you submit an appeal then to the SEN Tribunal, the local authority can't cease to maintain the EHC plan whilst the tribunal proceedings are ongoing. Now, the tribunal should take 12 weeks from the point that it's first registered to the final hearing. In practice, it's often longer than that. The tribunal is getting busier and busier, and although they are getting quite good actually, and have been quite good for a long time now at getting hearings through, the reality of appeals is there are often delays. Parties might make applications to move the hearing date for whatever reason, and whilst all of that is ongoing, the EHC plan would continue. Now, if you add up all of those time-saving measures that I've discussed there, you're essentially, from the point the local authority first say to you, we're going to cease to maintain this plan, you're looking at anywhere up to 9 months to a year of additional education, just because you put in an appeal. Even if you didn't win, that's an extra year at college or at school or with the EHC plan, depending on the circumstances. So it's well worth thinking about. Now, moving on to talk about the law around ceasing to maintain an EHC plan. So Section 45 of the Children and Families Act sets out the correct legal circumstances in which a local authority may cease to maintain an EHC plan. There is also some stuff in the regulations which is very case specific, so I'm not going to cover it in massive detail. And there's also guidance that you can find in the Code of Practice, but this is what a local authority should be talking about and should be referring to if they are ceasing to maintain an EHC plan. And the reasons are very limited. So the reasons are that they are no longer responsible for the child or young person. So that really would only relate in most circumstances to that young person actually moving out of the area. If that young person no longer lives in their area, then the local authority is no longer responsible for them, purely because they're not in their area, but of course they would still be another area's issue. Or that the local authority deems that it is no longer necessary for the plan to be maintained. Now, necessary is a word that comes up a lot in SEN law. We've got loads of case law about it, and I will go over it a bit with you and the circumstances in which it may not be necessary or may be necessary for a plan to be maintained further on in the presentation. But the law sets out that one of the circumstances in which it is no longer necessary for an EHC plan to be maintained either for a child, bearing in mind that it can happen any time, or a young person, includes where the child no longer requires the special educational provision satisfied in the EHC plan. Now, that is what local authorities will tend to try and rely on. They will say this child has now reached the magic age of 18 or 19, or this course has come to an end, and we've decided that they no longer need the provision. They just don't need it anymore, so the plan can be ceased. When coming to a decision, when determining whether or not a person, this is specifically for young people aged over 18, so that's for those of you listening who have older young people, no longer requires the special educational provision specified in his or her EHC plan, a local authority must have regard to whether the educational or training outcomes specified in the plan have been achieved. Now that, if you watched Hayley's webinar or if you tuned in, if you haven't, I do recommend that you go and watch it. She talks a lot about annual review preparation, but this is really where your annual review prep comes in. Because when you are looking at outcomes in an EHC plan, what you don't want to do is be too overly positive, thinking, let's sell this provision, it's really working, all of these outcomes have been achieved. Because if all of the outcomes have been achieved, particularly in the case of an older young person, that may well invite the local authority to cease to maintain the EHC plan. It seems very counterproductive, not to say how great things are going. But when you are in a review situation, when you are looking at outcomes, it's always best to be pragmatic where outcomes have been achieved, because we all want young people to be achieving outcomes. What we want to be doing is saying, this is what they could achieve. With this provision in place, with the EHC plan continuing, this is what we would expect this young person to achieve. Just touching on now, what happens if the young person has already left their school or college? So again, this is a very narrow set of circumstances in which this would happen. Generally it would be because a young person has either decided to stop their education, they've just woken up one day and said, I'm not going to go anymore, or potentially a placement has broken down. Some local authorities, the more unscrupulous ones, might use this as a way of saying, right, well, this young person doesn't want to go to college anymore. Perfect, we'll cease to maintain the EHC plan. Now, the legislators thought about this, and so within the regulations, what they stated is that where a young person who is aged over 18 suddenly ceases, generally in year, to attend the institution or the setting which is named on their EHC plan, the local authority cannot automatically cease the EHC plan. They have to call a review of the plan, and they have to seek the views, wishes and feelings of that young person to determine whether or not they want to continue in education. That's a really, really narrow and specific bit of regulation, but I do know, particularly in the context of COVID, we are seeing an increase in school and college refusal. So just in case that was helpful to you, I wanted to put that in there. Now, the word necessary, we're going to talk about that bit, because necessary is if you remember the legal test, so it's that a plan is no longer necessary. So what does that actually mean? Well, I can't give you a hard and fast answer, unfortunately, because it's really, really case dependent. So what might be necessary for me won't be necessary for you. And it's the same with children with EHC plans. What's necessary for one won't be necessary for another. But the case of B&M and Cheshire East Council from 2018 looked at what necessary might mean. And it looked in more detail at the statutory provisions and the suggestions that one of the things local authorities could do is look at whether or not the outcomes have been met. And what the judge decided in B&M was that for children over 18, the local authorities can look at outcomes. You know, it is set out in legislation and it's also in the code of practice. They can look at outcomes have been achieved in order to decide whether or not an EHC plan remains necessary. However, what they also said is that it is not determinative. So that is not the only thing that local authorities should be looking at, and not the only thing that they can look at. And what the judge actually said and made very clear was that if the legislators had intended outcomes to be the be all and end all, they could have written that into the law, and they chose not to do that. So that couldn't have been their intention. What the judge did suggest is that some of the other considerations could be the young person's educational and training aspirations, the reasons why the outcomes were achieved, and whether the young person's special educational needs profile has altered as she or he has matured. Now, I just want to give you some practical examples of those different areas. They were just suggestions by the judge. They're by no means open and shut things that you can rely on. If there are other things in your specific case that you think would show why an EHC plan would stay necessary, then by all means do. But just to give you a flavour, so looking at young person's education and training aspirations, it could well be that this young person has attended college for 2 years and has obtained a degree in IT or a college course in IT. And actually what they want to do now is to go on to yet another college course looking at graphic design with the overall aspiration of going into a career in IT design. Absolutely fabulous, very well achievable for a lot of young people with EHC plans. And that would be taken into account, because essentially if the EHC plan were to cease and this young person to be pitched back into college for an additional 2-year course with no special educational provision, those aspirations could be completely quashed. So there's an example of that for you. Looking at the reasons why the outcomes were achieved, that is attributing to provision. So why was this outcome achieved? This young person has been well supported potentially in a specialist setting or receiving speech and language therapy once a week. And actually these outcomes haven't been achieved because this young person has reached the very limits of what they're able to do in life. Those outcomes have been achieved because they've been receiving the right provision. And that's where we need to be looking at our evidence. What evidence do we have as to what outcomes have been achieved, why they've been achieved, and what we would hope and expect to see if that provision were to continue under an EHC plan. And point 3 there, whether the young person's special educational needs profile has altered, that might be that actually the provision is doing its job and some of the needs that that young person had have now been met. and they're actually functioning quite well now. Potentially they don't need that social skills group once a week for an hour because socially they're doing fine. But with those elements of with that progress being made, that doesn't mean the plan is no longer needed. It just means that the needs have changed. So they might need different provision rather than saying, well, that's done its job, we've got you to this point, you can have a conversation quite nicely without needing somebody with you, so let's get rid of the plan. It would be looking at what could we expect if we either provide different provision or if this provision continues. Paragraph 90 of that judgment looked quite critically at the decision, in this case a first tier tribunal decision where they decided that the plan should be ceased was appealed up to the upper tribunal. And so in this upper tribunal case, they were quite critical of what the SEND tribunal had decided, and they did decide that the tribunal had erred in law. And what they said is that where the determination is that a young person has more to learn and is capable of gaining some skills that would be of benefit to them in adult life, then that supports that special educational provision should continue. Now that deals with a circumstance where a local authority might be saying to you, well, we're going to cease to maintain the plan, but adult social care provision will do the job. That will step in, that will take over, and it will meet needs in a different way, but things will continue. What the upper tribunal suggested there is that no, if there is still progress to be made, that is actually supporting that the plan should continue, not supporting that the plan should cease, which is what most local authorities would try and say. Now, the SEN Code of Practice. The Code of Practice is subservient, if you like, to the legislation. So it's the legislation and the case law that's the really meaty legal bits. The SEN Code of Practice puts flesh on the bones of what the legislators intended, and it gives guidance which should be adhered to by the local authority. So I've just pulled out some key bits for you so that you know where to find them later on should you find yourself in this situation. So first, paragraph 7.6, this actually isn't in the section around ceasing to maintain, it's quite hidden, which is why I've highlighted it to you, states that all students aged 16 to 19 and students up to the age of 25 where they have an EHCP should follow a coherent study programme which provides stretch and progression. Now, I've highlighted that because local authorities tend to use that as a stick to beat you with. I see it quite a lot, particularly in the case of young people whose needs are potentially a bit more severe and who, rather than progressing towards specific qualifications, are instead making small steps towards life and independence. And what the local authority will try and say, or may try and say, is this is not a coherent study programme. Look at paragraph 7.6. They're not following a coherent programme of study. It's not going to result in a qualification, or some local authorities will say we don't like that qualification, we don't recognise that, we want to see a different qualification, and so the EHC plan should cease. But case law prevails, and Buckinghamshire County Council and SJ from 2016 held that it is in fact not necessary for somebody with an EHCP to be working towards any qualifications at all for them to require special educational provision. What is a coherent study programme is going to look very different depending on each child and young person's needs. Some children may well be working towards going off into the world of work and in professions and doing very, very well in life. And some young people may well be working towards developing as many independent skills as they possibly can, so that when their plan does cease, they could potentially be in supported living rather than residential care. So there's a big spread of children and young people that receive EHCPs. There is no requirement for a formal qualification, not anywhere in the law. There is no requirement for that whatsoever. So if the local authority is requiring it, then they're creating their own rules, and you don't have to worry about them. Again, this is very, very relevant to young people who may not be accessing formal education as the local authority may deem it, sitting down at a table and learning and doing exams at the end of it, but they will nevertheless be following a programme that's based on the development of their independence and life skills. Now, paragraph 9.151 This is where the local authority are talking about when local the Code of Practice is talking about when local authorities can't cease EHCPs. And again, this links into a few questions that I received beforehand. And what it says is that a local authority must not, bear in mind the word must, it's a demand, must not cease an EHC plan simply because a young person is aged 19 or over. And you would be staggered how many decisions we receive which say this child is 19 and is now under adult services, and so we're ceasing the plan, with no regard to the law or to the guidance. That happens a lot. The fact that EHC plans can continue to the age of 25 bears reflection to the fact that legislators have acknowledged that young people with special educational needs may need a longer time in educational training in order to achieve their outcomes and to effectively transition into adulthood. If they had intended that all children and young people, when they reach 19, don't need a plan anymore, then they wouldn't have allowed for plans to continue to 25. Then we're moving on to paragraph 199, and there are a stream of paragraphs in this section which relate specifically to cease to maintain. A local authority may cease to maintain a plan only if it determines that it is no longer necessary for the plan to be maintained, or if it is no longer responsible for the child or young person. That is a replication of the law, if you remember, from a few slides back. That comes from the Children and Families Act. But it goes on at paragraph 9.200 to put some flesh on the bones of that. And it suggests that the circumstances where a local authority may determine that it is no longer necessary for the plan to be maintained include where the child or young person no longer requires the special educational provision specified in the plan. When deciding whether a young person aged 19 or over no longer needs the special educational provision specified in the plan, they must take into account whether or not the educational training outcomes have been achieved. And again, and I've bold underlined it there, local authorities must not cease to maintain the plan simply because the young person is aged 19 or over. Age is not a reason until, of course, the plan naturally ceases at the end of the academic year in which the young person turns 25. That's the only time that the age matters. They can't cease it just because the young person has hit the age of 19 or over, and the local authority now want to pass that budget on to adult social care. So, practical guidance for you. What can you do to try to prevent a cease to maintain decision being made in the first instance? As I said earlier, please go and catch up on Hayley's webinar if you didn't watch it live, or if you haven't watched it yet. That she talks in great detail, and in far more detail than I have time for, about the way that you can prepare for an EHCP, but I've included some guidance for you to get you going. So as a starting point, please go into every review, regardless of your child's age, with the expectation that a cease to maintain decision may be on the cards. It is unlikely for children younger than 18, 19. We don't see it very often, but it is a possibility. So if you go into every review thinking, how can we head off a cease to maintain decision, then you can't go far wrong. And Hayley talks in detail about the different ways that you can prepare. But in terms of a cease to maintain decision, you want to focus on the progress, but progress that is attributable to the special educational provision and where you're at a placement that you want to maintain that placement as well. Attainment where applicable, so that's, we're moving towards outcomes. We've hit one outcome and now we've amended it. We think they can achieve this outcome in the future. Be very clear on those future outcomes. You want them to be specific, measurable, achievable, etc., etc. And you want to be able to show the progress over time. And preferably, you want as much evidence as you possibly can get that those are the outcomes that are to be expected. As I'm sure many of you will sadly have experienced, local authorities have a really nasty habit of ignoring what parents have to say and ignoring those parental views. So if, for example, you do have a treating therapist or specialist teacher or someone like that, get them to put into writing and provide as much evidence as possible, the progress and the outcomes that you could expect to see if the plan continues. Your hopes and aspirations, very important. What do you want for your child? But really, really important, and it actually can't be overstated, the hopes and aspirations of the young person themselves. Now, where a young person is able to give views, whatever those views might be, they really should be taken, they should be at the fore, and they are taken into account as set out in that case law. They're very important when making decisions on ceasing to maintain. So if a local authority wants to cease to maintain an EHC plan and the young person wants to continue in education so that they can potentially go on to onto paid employment in the future, and the evidence suggests that that's a realistic prospect, then that would support the need for an EHC plan to continue. So please do try to involve your young person's views wherever you can. The tribunal are also going to want to see and hear those views. So it's really, really important that you get them down and that you do include them in the process as much as possible. I've bold and highlighted there, evidence, can't stress it enough. Everything that you ask for, everything that you're saying really does need to be supported by as much evidence as you can possibly get from as many people and professionals as you can possibly get. So you've had your review or you've had your consultation letter, it depends what comes first, and the local authority has said to you, we're considering ceasing to maintain the plan, assume that they followed the correct legal procedure. So what do you do then? And again, much like a review, it's all evidence. Always respond in as much detail as you can muster and do it in writing. When you provide it to the local authority, do it in a way that you can prove. So you either want an email and ask them to acknowledge receipt or put a delivery and read receipt onto the email itself. If you're sending it by post, send it by a way that is trackable. If you deliver it to the local authority by hand, get a signed receipt. You want proof that you've submitted those views and that you've consulted. Reference the relevant legislation, case law and code of practice. I've set it out here for you. And we do various newsletters and things that cover topics like this as well. Any case law updates we'll probably be reporting on, so do keep an eye on our newsletters and our social media. We're always talking about the updates. The reason I say this is that it puts the local authority on notice that you know what you're talking about, that you know the correct law, even if they're deciding to ignore it, and may well dissuade them from ceasing to maintain the plan unlawfully in the first place. Provide the young person's hopes and aspirations as much as possible, and that can be in whatever format they're happiest with. So a written statement, typed or handwritten, they might voice record something, they might do a video call, whatever they're most comfortable with, get those views in, which will hopefully say, I want to continue in education. Coordinate with the educational placement if at all possible. So the local authority do have to consult with the educational setting as part of the consultation process as well. And if you are on really good terms with the setting, then it's really good to coordinate your efforts, arrange a meeting with them, take your notes and sit down and work through what they're planning to say, what their evidence is to support it. Hopefully you're all singing from the same hymn sheet, and actually what you're doing is doubling the evidence before the local authority as to why the plan should continue. And keep on top of them to consult. And I don't mean this, I'm sorry if you work at a school and you think I'm getting at you, it's not my intention, but parents, please do keep on top of the school to ensure that they do consult in a timely manner. There's lots going on at the moment in particular, you know, teachers and SENCOs already have a really big job on their hands as it is. COVID has made things even more stretched. And so we have had circumstances in which schools have actually taken too long to reply to the consultation, and the local authority, mindful of the fact that they can't cease to maintain the plan immediately, and with the long-term aim of getting it ceased by the end of the academic year, may well go ahead and actually issue that decision without the school consultation being considered. So you've done all that, but what if it doesn't go to plan? Worst case scenario, you've had your review, you've consulted, you've given them all of your evidence and waxed lyrical about why this plan should continue to be maintained, and they've come back to you and they've said, no, we're going to cease to maintain the plan. What do you do then? Well, that is when you will have your right of appeal to the SEN Tribunal. Talked about it earlier, but just to recap, right of appeal runs for 2 months from the date of the covering letter and can be extended by 30 days by the mediation certificate. Whilst the appeal is running, whilst you have that right of appeal, the local authority can't cease to maintain the EHC plan. So that includes maintaining the placement. If there is a placement named in section I of the plan, and hopefully that's the placement you want your young person to stay at, the local authority have to continue to maintain that place. If they don't, then they can be challenged by a pre-action letter, as I discussed earlier. If you're in a situation where your young person cannot stay at their placement beyond, within those timescales, that there will be a transition, then the local authority have to continue acting as, that plan is in force. They have to find a placement, or if you come to an agreement that a placement isn't suitable, potentially you want a residential specialist college, and the local authority may say, well, okay, we'll arrange for you to go to the local college, and you don't want that. They should be agreeing to make some sort of special educational provision in the home in the intervening period. It's very, very case specific, but those are some of the options available to you. And it's really important, as a final note, when talking about the SEND Tribunal, to say that they are fully impartial and they will only apply the law. Now, that's really, really frustrating, because often local authorities have behaved really, really badly. Really, really badly. And you want the tribunal to know about it, completely understandably, but it will not influence the tribunal's decision. Okay, the tribunal aren't interested really in party behaviour. We say before the decision was issued and before the appeal was submitted, but in practice what we're seeing is the tribunal don't care much about behaviour when the appeal is running, so long as everyone's doing the bare minimum to keep things ticking over. So talking about the fact that the local authority didn't consult properly, or didn't get the views of the school, or didn't tell adult social care, these were all things to maybe get the decision reversed in the first instance, but they're not relevant to the tribunal. What the tribunal wants to know and what they're focusing on is what are the young person's needs, what is the provision, and does the EHC plan need to be maintained in the context of them. It's also really important to note that as part of a cease to maintain appeal, the tribunal can consider changes to the other sections of the EHC plan. So they can consider the needs in section B and the provision in section F. And if you are looking for a change of placement, they can consider that as well. And it can also be registered on the national trial. So an appeal about a cease to maintain decision is not only about ceasing to maintain the plan. If you need it to cover the other sections, then it can do so. Now that was a real whistle-stop tour of ceasing to maintain. I'm going a bit hoarse. There was a lot of information to give you there, but thank you for your time and for listening. And now we're going to get down to some of the questions that have been coming in. I've not actually had the screen open, so I'm not sure how many we're dealing with right now, but me and Hayley are going to go through them for you now.
It's okay, Nicole, it's manageable. So just to let anybody know who's obviously now going to use this opportunity to ask some questions, I am going to ask Nicole some of the more popular questions that have popped up, and also some of them that I've flagged as answering live, because these are things that we often hear day in, day out in our practice, and I think parents need to be aware of. So I will ask Nicole the questions. Feel free to keep popping your questions in the question and answers session, and we will obviously be running the webinar until 8 or slightly over if we manage to get over, and answering as many questions as possible. So are you ready, Nicole?
I am as ready as I'm ever going to be. Let's do it.
The first one says, my local authority, it's an anonymous attendee, my local authority has said they'll maintain my daughter's EHCP until the end of post-19, but seem unable to explain what this means. Any ideas?
Okay. I don't know what it means, but I can talk about the law. And it really depends where you are. So have the local authority decided to cease to maintain? It sounds like not. It sounds like they're telling you that they're thinking about it. What it means is that a consultation should start. Obviously, I don't know from your question how old your daughter is or how far into the future they're looking. In practice, they should be looking no further than a year. Okay, so if your daughter is, for example, 17 and they're saying in 2 years' time we're going to cease to maintain, it's too early for them to do that. They're prejudging the progress that your daughter might have made in that time. They're prejudging what her aspirations might be in that time. So what really needs to happen now is for the local authority to be challenged. Nail your colours to the mast. What are you actually saying? Are you telling me you're considering ceasing to maintain? If so, then the consultation with yourselves, the school, adult services, all needs to happen.
If I can just add on to that, Nicole, because I think this might be one of those situations that we see quite a lot where parents are informed we'll secure funding for one more year or till the end of post-19. And sometimes actually schools and colleges fall into this difficulty because what they do is they set, for example, a 1-year course or a 2-year course without actually taking into account, we don't know at the end of that 2-year course whether that young person is going to have met their outcomes and satisfied the test of whether the plan is still necessary. So if you're a professional or a school watching this and you run annual reviews, just to add that on there, when you add that limiting, for a year or for 2 years, you can actually make that much more difficult for parents. So there is no need to do that because obviously EHC plans are reviewed on an annual basis. So the next question, we've answered that one. The next question is, this is kind of related to the COVID situation, but I think it'll help many parents.
Okay.
Another anonymous attendee. I have 2 teenage daughters with EHCPs whose attendance at college, study and provision has been knocked into touch by COVID. We're hearing this a lot.
Okay.
They barely attended. They are doing virtual learning, but it's nowhere near satisfactory. Is there an argument for them to repeat a year or even 2 years to make up for what they've missed? And I think there's a lot of parents wondering about this at the moment.
Yeah. So the answer to that is yes, and that was the case even before COVID. So quite often you would have young people who, for whatever reason, have missed parts of education. Maybe they've had some sort of mental health crisis, maybe there's been a bereavement or some other reason why the plan should continue. So yes, that is, if you like, an inbuilt reason. They've missed a year of education. That is a reason why the plan should continue. But it's not the only reason the plan should continue. So if you go back and look at the slides after, once this webinar is published, you want to be focusing on outcomes. Actually, have they achieved their outcomes? Have those outcomes regressed during COVID? Lots of young children have unfortunately experienced regression because they're not receiving their proper provision, or it's very sporadic. They've become socially isolated and all those sorts of considerations. So yes, it can help scaffold the reason why a plan should continue in the interim. Hopefully they wouldn't cease to maintain it, but if they did, you want to be looking at all those other factors as well.
There seems to be a common thread in these next 2 questions, and I think it's in relation to education departments trying to put provision onto social care, which obviously is one of your domains anyway, Nicole. So the question from Hilary Malcolm is, when amending a plan after an annual review, can the local authority suggest or decide on a local day provision, which will mean that the EHCP will cease if it's attended by the young person, e.g. a community provision which focuses on drama, singing, a bit of travel training, but no stretching training, SALT or OT or relevant qualifications, particularly if the young person is currently at residential provision? So I think that's a situation where they're obviously suggesting social care rather than actual education placement.
Okay, so the local authority can suggest whatever they like, and they tend to come up with all sorts of outlandish decisions, and you too can suggest whatever you would like, and that's really important. You can require the local authority to consult with pretty much all categories of special educational placement. If they do decide to name this place, your question's a little bit of a contradiction. If they name a different placement, that suggests they're naming it in section I of the EHC plan, which means that the plan will continue. Naming a placement which on the face of it doesn't need an EHC plan does not automatically cease the EHC plan itself. The local authority still have to go through all of the rigmarole of consulting. They can't cease to maintain the plan while you have a valid right of appeal. They can't cease to maintain the plan whilst the appeal is before the SEN Tribunal. As part of that appeal, if you were to make it, I would assume that you will be pushing for continuance at residential provision, or maybe moving to a different residential provision if they've reached the upper age limit for the one that they're currently at. And the local authority have to make arrangements for that provision to be enforced while that appeal is running. So just to give you a little bit of reassurance, the local authority can't just pull the rug out from under you and name this provision, get rid of the plan and all of its provisions, and then leave you trying to muddle on through whilst you go through the SEN Tribunal procedure. If they want to cease, they have to follow the correct procedure, and then you do have that right of appeal, which I would really, really urge that you take, because even if you really don't have the stomach for a fight with the local authority, although we love a fight with a local authority and we highly recommend them, where they've been behaving badly and behaving unlawfully, but by going through that process, you're probably going to be extending that EHC plan from anything between 6 and 12 months anyway. So it's well worth doing.
This was another question that was actually answered as we were going through, but it's quite a helpful question from Robbie Marr. So I think it would be just a good one to also answer live. So Robbie says, with COVID disruption to provision, can they still seize if all of provision not delivered? Can they also seize if the learner has been shielding?
Okay, that's very similar to the previous question we had about COVID. They can't cease because of that. You know, they can't say, oh, this person hasn't been receiving their provision and everything's okay, so actually we're going to cease to maintain the plan. Those would be reasons to argue why a plan should not be ceased. Disruption in provision, potential regression, everyone's been feeling it across the board, but particularly children with SEN who've really been disproportionately affected. There's lots of studies coming out now that talk about how children and young people with special needs have been disproportionately affected by the COVID situation. So if anything, it supports the need for an EHC plan to continue. And again, can't stress it enough, if the local authority want to cease to maintain the plan, they have to go through the correct procedure. They can't cease to maintain it overnight.
Next one, Nicole, this is again a bit of, it's not necessarily just cease to maintain, it's more annual review. But obviously we love talking to parents about all of these issues, so I'll read it out to you. It's from D. It says, my son is 23 in May. College are offering 3 days next year and he does 5 days at present, saying he has to go to adult social care. They have said they will say they can't meet his medical needs if I request 5 days. Can they do this?
Okay, so it sounds like the college are behaving badly. I'm not sure there's any local authority involvement at the moment. So he's doing 5 days at the moment. They've offered 3 days next year. They're saying that he has to go presumably over to an adult social care package. The fact that he's 23, as I've already said, does not mean that his needs are social care needs. They are still educational needs. They've threatened you essentially and said they'll say they can't meet need altogether if it's over 5 days. I would question what they're expecting to happen next year that will mean that this year for 5 days they're perfectly fine, but next year they can't meet medical needs. That has the hallmarks of a potential claim for disability discrimination in there. So that's something to bear in mind.
I also wonder if this is a funding issue, Nicole.
Yeah, potentially. Now, if it is that the college are finding actually they're providing for your son for 5 days a week, and because of the level of provision that he requires, they're out of pocket, and actually some of the whole college budget has been used on his provision, then that is a problem that the college need to be taking up with the local authority, and that is what Richard Nettleton is going to be talking about in his webinar. So maybe one to direct the college to register to come and watch. If there is a problem about provision, and there is a problem with the plan itself, and the EHC plan doesn't contain enough provision for them to be able to meet his needs, then they should have been raising that as part of an annual review, just normal review, to get the provision increased. They shouldn't be raising it now essentially as a threat when you're coming up to transfer. Presumably you will be transferring, we're talking about the coming transfer period, so the start of the term next September, and placements should be decided in the coming weeks for young people that are transitioning between post-16 provisions. So that decision needs to be in for 23-year-olds, so children of your son's age, 5 months before the transition is due to happen, which will probably fall in February, depending on your last day of term. So really the local authorities should already have had the transition review. They should be in a position now to name where he will be attending. And I think what really needs to happen is a frank discussion with the college why they're now making these noises and coming to these decisions, because the legal position is not that he has to move over to adult social care. That has no basis in law at all.
Okay, thank you, Nicole. Another anonymous attendee, one of the questions here is, Can they cease to maintain at age 19 if your child has not completed their GCSEs A-levels but need online provision instead because of their mental health? And I think we're seeing a lot of these questions about mental health, particularly in light of obviously the current pandemic and changing circumstances.
Okay, so the answer to that is no, they can't cease to maintain on that basis. Again, if you think of Regulation 30, there's specific provision there that if a young person has, for whatever reason, left their provision suddenly in the middle of a year, that is not an invitation for the local authority to cease to maintain the plan. What that is actually a trigger for is a formal review process where they can come along, obtain all the necessary evidence, and actually obtain your son's views about his education, why he's not going to college at the moment, whether it's COVID related or something else, and actually ascertain what he wants to do for the future. If what he needs to do for whatever reason, be it mental health or the need to shield or anything like that, and he needs to move away from a more traditional educational institution and be schooled at home, then that can be done, well, it should be done and can be done under the EHC plan, and that's called education otherwise than at school. And if you go and have a Google and have a look on our website after this, I've actually written about education otherwise quite a lot, and we've done webinars on it in the past as well. But basically, that is the formal arrangements under Section 61 of the Children and Families Act, where your son can be educated at home, but through an EHC plan. There's no need for that plan to cease.
Thank you, Nicole. A question from Ruth Blinko, and you'll be glad we're getting to the end of the webinar, so you'll soon be able to rest your voice. But a question from Ruth. My 16-year-old daughter started an apprenticeship in September. She has an EHC plan, but it was based on her attending college and is therefore not relevant. Oh, it's just moved. Hold on a second. Somebody asked a question, it jumped up my page. There is no named provider on it. I have amended it several times to make it more appropriate. Can it be seized for this reason? Obviously, we don't have all of the details there,
yeah,
but
there's a lot going on there. It can't be seized for that reason. It sounds to me like a review needs to happen. I don't know what review you've had where you found yourself in a situation that the local authority have actually issued a plan that bears no resemblance to even the course that your daughter is attending. It is a legal requirement that your daughter's EHC plan does contain either a specifically named provision in Section I or the type of provision that they think is appropriate for her, and that includes apprenticeships. So if the plan is not reflective of actually what needs to be in place for the apprenticeship to be successful, then what you really need is a wholesale rewrite of the EHC plan, certainly not a cease to maintain. The fact that the local authority incompetent is not grounds to cease to maintain an EHC plan.
Okay, perfect. Thank you, Nicole. We've got about 2 more questions to get through, and then we can let everybody on with their evenings and putting children to bed, including your own, Nicole. So 2 more questions we've got going on here. This is again from an anonymous attendee, and it says, my daughter, who's 19, has an EHCP, but has not made progress on the performing arts course. The college have said, therefore, that they will not offer another year on the same course, which leaves me looking for another setting. Oh, somebody's just done that thing where they asked a question and sent it shooting up. I'm worried my local authority will use this opportunity to stop the plan. What is the best course of action?
Okay, well, at this point, you should have had your transfer review if actually she is going to be moving on, although it's not clear whether it's just the course that's the problem or the college itself from your question. I don't know whether you'll be staying at the college doing something else or whether you're looking wholesale to move over to a different provision. That's not clear, but the question disappeared, sorry. I'll try and answer as best I can. So the fact that she's not made progress on the performing arts course is not grounds to cease to maintain the EHC plan. An educational course for a lot of children with EHC plans are really just the tip of the iceberg in terms of the provision that they're getting and the progress that they're making. So although, you know, she may not have come out with a qualification from the performing arts course, she may have made progress in other areas, and it's very unlikely that the actual outcomes in her EHC plan say that her outcome is to achieve a specific qualification on a specific performing arts course. It will be broken down into much more manageable chunks. It might be looking at social skills, it might be looking at sensory needs or speech and language needs. So that's not the be all and end all. The course is not the be all and end all. I suppose what you do want to be thinking about in practical terms is actually what are the young person's views, wishes and aspirations. Is the performing arts course a real passion for them? If the answer to that is yes, then I wouldn't say move away from performing arts altogether, but there are specialist colleges in the country, across England and Wales, which offer performing arts, which are much more geared up to meet the needs of learners with special educational needs, and which hopefully would be able to provide her with a much better provision to enable her to make progress on a course that she's passionate about. From what I remember from the question, you were concerned that they might do it. And that's concerning to me, because you should have an indication that that is what they're going to do. As I said, they do have to write to you and to make you aware that they are considering ceasing to maintain the EHC plan, and then consult with you, consult with the college. It doesn't sound to me like the college is saying she doesn't need a plan anymore, just that that particular course wasn't right for her. And if the practical effect of that course is that it's just a bit of enrichment rather actually than providing her with the provision and the education that she needs to make progress against all of her outcomes, then they may be doing you a favour. But it doesn't sound to me like what they're saying is that she doesn't need a plan at all. And the local authority haven't consulted with you on that basis. So hopefully you'll be looking at a change of course or college as opposed to a cease to maintain.
Just before we go on to the final question, Nicole, just in case anyone missed it, obviously us saying so earlier, firstly, this webinar is being recorded and it will be going out on all of our social media channels in the next couple of days. I did mention that on my webinar, and then I got inundated with about 50 emails asking me exactly that question. So it will be going out on our Facebook, Twitter, LinkedIn, Instagram, and you'll have the full recording available to you to keep referring back to. Also, if you're enjoying the webinars, please do contact us on any of our social media channels, because we really listen to what parents need from us, and that's how all of these webinars are created. So if you think they're good events, if you think they're helpful, if you think we should cover other subjects in the future, please do come back and let us know, because it's feedback to me that get the whole team on board to do these webinars for free for you. And just a reminder, obviously, if you're in this, you're in the SEN sphere, we have got 2 more webinars coming up live in January. We've got one with James Brown next Wednesday evening at 7 p.m, covering EHCPs and everything in between. Poor James will definitely have lost his voice by the end of that one, because that's covering the whole sphere of the Tribunal. And then Richard Nettleton is covering recovering funding for schools. So all of the parents who have put on here this evening that they are struggling, you know, being reduced down from 5 days to 3 days, etc. All of those things sound like they're a bit of a funding issue, and you should definitely be shoving the colleges and the schools in our direction to listen to that webinar, because what we don't want children and young people to have is a restriction on the provision that they need because of funding. We want to make sure that funding is actually in place properly for them. So just a reminder about those webinars and the fact that this is being recorded, and it will come out to you as soon as we can possibly get to it. Obviously, we are advising clients all day and night at the moment, so we'll get it as soon as possible in the next couple of days. So the final question, Nicole, I hope it's from a phone. If not, somebody's got a very cool name of Galaxy A71. The question is, can my son's school force me to accept a different setting based on the fact that he cannot access 50% of the mainstream curriculum? And just to say as well, we get this a lot, and you have to remember that schools aren't the local authority, even though they pretend to be sometimes. Schools can't actually change your EHC plan, but I'll let Nicole answer in more details. The question is, can my son's school force me to accept a different setting based on the fact that he cannot access 50% of the mainstream curriculum?
Yeah. Now, this is not about cease to maintaining, but we'll allow it. We'll allow it because we love to answer your questions. So the short answer is no. So you have an absolute right to mainstream education for your child if that is the education of your choosing. All of the law is premised on the fact that mainstream education should be the starting point for all children, and that we should be looking at provision within the mainstream school to make that a reality and to make it success. So if you absolutely want to continue in mainstream education, then that's your decision and that is your legal right. Now, the reason that's the short answer is that there is unfortunately a slightly longer answer to go on to that. And that is that although there is that presumption that there is that right to mainstream education, if the school can actually evidence that either your child's placement there is incompatible with the efficient education of the other children, or if they can show actually that they are unsuitable to meet your child's needs, then they could successfully argue under the law why they shouldn't be named as the ongoing placement for your child. Now, 50% of the curriculum actually isn't bad going. I've definitely seen worse and local authorities trying to continue to name mainstream. So there's a good chance that even if the school do go to the local authority and say this child is only accessing 50% of the curriculum and we don't think they should be placed here anymore, that the local authority will say we don't care and actually we're going to continue to name you. It's what the parent wants and that is what we're going to continue to do. With regards to the efficient education of the other children, just to drill down a little bit more into that for you, that's actually really quite difficult to prove. Satisfying anybody, including the tribunal, that a place is incompatible with the efficient education of the other children is very, very difficult. And generally, you would be looking at huge class disruption. So potentially we're looking at the entire class can't learn, maybe because the child is throwing chairs or is attacking the teacher, or is screaming very loudly to the extent that a lesson can't go on, and that's happening persistently day in, day out, as opposed to a one-off occurrence, maybe when a child is emotionally dysregulated. With regards to not being able to meet need, rather than just saying on the part of the school, we can't meet need, the question is, well, what needs to happen for you to be able to meet need? Rather than moving your child out of mainstream and potentially into a form of education that you obviously don't want, what provision is required, and by and large, what funding is required to make that a possibility. If they're saying actually your child needs full-time one-to-one, fine, put it in the EHC plan, the local authority have to pay for it. It's not coming out of the school's budget, and hopefully that will alleviate the problem. If it's a communication issue, do we need to look at speech and language therapy? If we're looking at dysregulation because of noise or potentially the need for movement breaks or sensory difficulties, do we need OT provision? So rather than essentially trying to kick your son out of the school and into special schooling, which you'll be pleased to know everything is geared up to stop. The law is specifically there to try and stop mainstream placements from funneling all of its special education needs children out of mainstream education. Then really what they need to be doing is justifying why the provision isn't appropriate and what provision is needed instead.
Thank you very much, Nicole. That does conclude the Q&A section, and just want to say thank you to everybody for joining us tonight. It's been we're very grateful to have you with us in these uncertain times and giving up your very precious time that we know parents have to dial into one of our webinars. So thank you for Nicole to hosting the webinar, and thank you to you all for attending. We gratefully appreciate it, and we hope to see you at one of our future events.
Yep. Thanks, everyone.